staying warm, other than Representative Jennings, who's always cold-hearted. Good to see everybody. This is it. We have 3 bill hearings today. We'll get started with the first one. I'll open the hearing on House Bill 2377 and ask Natalie to give us an overview of the bill.
Mr. Chairman, actually, Jason practically begged me to let him brief these 2 DUI bills for you. So he's going to do those for us.
Well, then we will definitely let him do so. Jason?
Thank you, Mr. Chairman. I think that's a little bit of an exaggeration, but that's all right. Mr. Chairman, Jason Thompson with the Revisor's Office. House Bill 2377 is the bill revising the laws concerning driving under the influence. It includes authorizing reinstatement of a driver's license for certain persons with an ignition interlock device restriction, requiring persons with an ignition interlock device restriction to complete the ignition interlock device program before driving privileges are fully restored or reinstated, provides for reduced ignition interlock device program costs for certain persons, and also modifies the criminal penalties for driving a commercial motor vehicle under the influence and driving under the influence. So you've got a pretty substantial bill brief that I put together based on last year's bill brief for SB 405, plus all of the new pieces that are in this bill. I'll try to hit the high points. I know you've got some very good conferees that can give you a lot more background on this as well. So let's just say section 1 is the section you may remember from last year that removes section 1 you won't remember from last year. This is a new section that creates the ability to reinstate a driver's license for certain folks who have a restriction to operating only a motor vehicle with an IID, an ignition interlock device, installed on it. You have to apply to division, and the division can reinstate you if you meet the criteria found there in section 1. Section 2, then, you may amend from last year, or you may remember from last year. It amends KSA 8-235. So current law allows certain DUI offenders to get a Class C license for the operation of a motorized bicycle, but this would remove that provision. It's apparently very rarely used and can qualify us for some federal funds, I think is what you'll hear. So this removes that ability to get a motorized bicycle license. Section 3 then amends some of the commercial DUI and commercial driving statutes, KSA 8-2, 142. Certain provisions disqualify you from driving a commercial motor vehicle for life. Subsection C is amended to deal with the look back period, as it's called, and limit the time that you're looking back for second or subsequent offenses to after July 1st of 2003. So that would be a change in the current law. There's also a provision in the current law that allows the Secretary of Revenue to adopt rules and regs that make guidelines for how you can get your life disqualification reduced to not less than 10 years. Apparently that's not been done. And so the replacement provision in this bill gives a statutory framework for that restoration after you've been disqualified for at least 10 years. So you might not be disqualified for life any longer if you meet the criteria established in the statute. Finally, I'll note subsection E of that statute. We've added a provision from federal regulations that bars a person from driving a commercial motor vehicle if they have used a commercial motor vehicle in the commission of a felony involving severe forms of trafficking in persons. So those folks are disqualified under the federal law, and that's added to our state statute. We also have a provision there about folks who may have been disqualified for incidents prior to July 1 of 2003, that new look back time period, they could apply and ask for review and modification of their disqualification. So that's 8-2-142. Section 4 is 8-2-144. That's the crime of driving a commercial motor vehicle under the influence. You can see there are several changes to the penalties. I tried to describe them in a narrative way. I know in the testimony you have more of a chart form that may be easier to follow. Just know that those penalties are different here than they are in current law. Some may be a little higher, some may be a little lower, some more about how the time is served in confinement versus imprisonment, work release, etc. So there's a lot of adjustments. But the big penalty increase is for third or subsequent offenses. We go from a non-grid, non-person felony, which is served in jail, to a severity level 6 person felony, which would be served in prison. So that's the big change in sentencing, both here and in the DUI statute. So I didn't want you to miss that. And certainly the conferees did not. You'll hear testimony about that. I did a little preview of what Kathy sent out. The other thing I'll note here is both in this statute and DUI, except for a $250 fine that's required to be remitted and credited to the Community Corrections Supervision Fund, the bill would authorize the district courts to waive most of the fees provided by this section, the fines imposed by this section and the DUI section. So that's a new change as well. The last thing I would note on DUI and commercial DUI is that there's a provision about plea bargaining in the current law, and there's some clarifying language in there about what that means if you're dismissing a charge because you don't have the ability to prove it beyond a reasonable doubt. And I see Mr. Breitenbach and Mr. Norton on my screen, ready to talk about that kind of stuff later, but that's in there as well, some clarifications on plea bargaining. We then move into section 5, which is KSA 8-1015. That's where we get into administrative penalties for driving DUI related offenses. There's a waiting period in current law before you can apply for suspended driving privileges and get before you can apply for restricted driving privileges when you have suspended driving privileges. The bill removes that waiting period. So you'd be able to get interlock much quicker under this bill than under current law. And once you have that interlock, it also removes most of the restrictions on where you can drive. So rather than being just to and from work or something like that in current law, you would be able to drive anywhere with your ignition interlock as long as you're using that device. The other thing I would note in 8-1015 is the big change to compliance-based removal. You may remember we talked about this a lot last session as well. You'd have to comply and meet the program criteria before you'd have that device removed from your vehicle, rather than just serving out the time period that's required. Section 6 then gets into the rules and regs that the Secretary of Revenue has to adopt regarding that IID program that you would have to meet to get your device removed. I won't go into the details there. There's quite a bit in the bill brief and in the testimony. This does have the provisions about waiving your fees for the device or maybe paying a lesser rate if you qualify at less than or equal to 300% of the federal poverty level, or you're enrolled in food assistance, that sort of thing. So that provision is still in there. You may recall that discussion from last year. Section 7 then is the DUI statute, 8-1567. I kind of already went over the changes. They're the same as the commercial DUI for the most part. Some changes to sentencing, third time felony folks go from non-grid, non-person to severity level 6. Fourth or subsequent folks go from non-grid, non-person to severity level 6 on the grid. So that's the change there. Section 8 then gets into 8-1567A, which is the DUI statute for people under 21 years of age. The only substantive change, just like last time, is to clarify or change the number of days that you have to have restricted from 180 days to 180 days rather than 330 days as required by the current law. And I noted in the brief, this makes it match the penalty that you face under KSA 8-1015B1 on page 17. If you wanted to compare this provision and that provision on page 17, it would make those line up, and that was the point of the change. There's a discrepancy in current law. Then the last two sections, 9 and 10, are about diversion agreements. Section 9 is in Chapter 12 for city attorneys, and Section 10 is in Chapter 22 for county or district attorneys. Both of them are to clarify some of the language in there and make clear that a city attorney or a county or district attorney cannot hide commercial driving convictions. It's an anti-masking rule, I guess, is the lingo that they use in the division of vehicles. And so there's a lot of clarifying language to say that you're not allowed to enter a diversion agreement that would hide one of these commercial driver's license holders having a traffic violation or a conviction that is relevant to their CDL. I think that hits the high points, and I'll see if you have any questions.
Jason, Representative Ralph.
Thank you, Mr. Chair. I did want to just take a moment. We always get great work out of the revisor's office, but the the committee from Judicial Council that brings most of these recommendations has been meeting over the course of a little over 2 years. We've had legislation here in 3 different sessions now, and I did want to at least make comment that we've had tremendous work from Jason in regard to this particular subject and topic. He's hung with us through all that time, and did want to at least have the opportunity to make a public acknowledgement of the tremendous work done, and appreciate the recap here even today. So just wanted to make that comment, Mr. Chair.
Good. Representative Carmichael.
Thank you, Mr. Chairman. Following up on the Vice Chair's good words, not only has the Revisor's Office been of great help, but our Vice Chair, and I'll call him out by name, Representative Ralph, has served on the committee and spent substantial time and effort, as has one of our conferees, Mr. Breitenbach, from the Sedgwick County District Attorney's Office, and they should be commended as well. With that prefatory statement, Mr. Thompson, it is indeed a pleasure to see you appearing once again before our committee, particularly when there's a picture of the campanile at the University of Kansas immediately above your head on our screen. That makes my day brighter. That being said, my usual question is only modified slightly. Senate Bill 405 contains many of the provisions of this bill. Do you happen to know what fate SB 405 met last year so that I can report back to my caucus without looking it up myself?
Yes, thank you, Mr. Chairman. Jason again with the Revisor's Office. SB 405 did pass the Senate 39-0 last year. It did receive a hearing in this committee. It was passed as amended by this committee and then stricken from the calendar at the end of the session. It looks like it passed on March 16th, or was reported out on March 16th, and then your session ended early, not long after that.
Thank you. Pardon me. Thank you. My final question is, there is renewal of prior rulemaking authority that rests with the Department of Revenue, and then it appears that there is new rulemaking authority as it relates to new provisions in the law. Are there any time deadlines contained in this legislation by which the Department of Revenue must promulgate and adopt these regulations so that we can make sure that it does go into effect in a timely manner?
Thank you, Mr. Chairman. Representative Carmichael, I'm looking at 8/10/16 on the pages 20 or so. I don't see a time requirement, just that the secretary shall adopt rules and regs for this provision. And then I'm thinking the other one is in 8.
And I don't think I saw it either, Mr. Thompson. I just want to verify that is the case.
I'm looking at 8.2.142 as well. That's the other place that they would be adopting rules and regs, and I don't believe there's a date in there either. I know that's a preference of our rules and regs folks, and I don't know that the Judicial Council Committee discussed that, but we could certainly add that in if that's needed.
Certainly. And Mr. Chairman, I hope that our conferees will help us understand how much time the division needs to promulgate these regulations so that we can try to put some time deadline on it if that's the committee's will. Thank you, Mr. Thompson. Thank you, Mr. Chair.
Humphreys.
Thank you, Mr. Chairman. Just a quick question, Jason, on Section 7, and then I think it's also Section 4 when it's talking about commercial vehicles. If it's removing that requirement for a first-time offender, and then something about the second-time offender, what are the penalties for the first-time and second-time offender? Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Representative Humphreys. So Section 7 is DUI 8/15/67, and then the other one's commercial, and they're slightly different. Most of the language is the same in the two, but briefly, I'll try to not get in the weeds too much. But so in the bill, if you want to know what the penalties will be on a first conviction DUI, this is on page 22 if you wanted to follow along. On a first conviction of DUI, it's a Class B non-person misdemeanor, no change from current law. You're sentenced to not less than 48 consecutive hours, no more than 6 months imprisonment. Again, no change, or 100 hours of public service, and fine not less than $750, nor more than $1,000. So no change there. The change is then that you don't have to serve 48 consecutive hours or do your public service before or as a condition of a grant of probation or suspension. So that's a shift from current law. And then on your second conviction, you go to a Class A non-person misdemeanor, and you serve not less than 90 days nor more than 1 year in 1 year imprisonment. You fine not less than $1,250 nor more than $1,750. Those are not changed from current law again, but there's a current law requirement that you serve at least 5 consecutive days imprisonment before you're granted any other form of release, and that's removed. So there's just more flexibility on the front end, I guess. And our conferees can get into that detail a little bit more, but that's the change in the statute. Then there's a whole new section, a new batch of language regarding how you serve your probation that's granted under this section, and how you serve your 120 hours of confinement, how you calculate number of hours served in work release or number of hours served on house arrest. So that's the bulk of that new language. And then for a third conviction, you actually have a two-prong or a bifurcated penalty. For third convictions in DUI, you have one that's a Class A non-person misdemeanor, where you serve the 90 days to 1 year, again, with all the options for work release and house arrest and all that. And the other option is a third time conviction when you have a prior conviction that occurred within the preceding 10 years, not including any period of incarceration. So if you're a third time offender with a recent conviction, recent prior conviction, you actually go from a non-grid, non-person felony under current law, again, served in jail, and you would go to a severity level 6 non-person felony, which puts you on the grid, and you'd serve that in prison. And finally, fourth or subsequent convictions of DUI would go from non-grid, non-person to severity level 6 non-person felonies on the grid. So that may be more or less than you needed, I hope.
No, it was great. Thank you. I appreciate that.
Any other questions for Jason? Do not see any. We'll move on to our proponents. First one I have listed is Aaron Breitenbach.
Yes, thank you, Chairman. Fellow committee members, thank you for the opportunity to appear remotely today. That helped me tremendously. I obviously don't want to throw any shade at my fellow conferees. As you know, I appreciate the praise that was heaped on myself, but Jay Norton and Ed Klump also were on the same committee, worked with Representative Ralph and myself. So we all put in our time for sure, and it was an honor to do so. As I expect, the Vice Chairman has already shared, it was 2 years. It took a long time. And I stress that because I think it's of some significance that Mr. Norton and I, who in our day jobs are about as diametrically opposed as possible, are both speaking in support of this legislation. That should give you some comfort that what we're proposing is the result of consensus and compromise, and not straying too far from the middle either way. Candidly, there were things that probably both sides would have liked. For example, I would have liked to have gotten more into the area of regulating drug impaired driving. We couldn't come to a consensus on that. So be it. But here was a place that we could. And so I say all that as a preface. I'm going to be speaking primarily on the criminal portions of the bill. Mr. Norton will be speaking on the administrative side, and Mr. Klump will be speaking a little bit all over the place, but primarily on the flying into the influence bill that he helped us generate. So as a starting point with the penalty provisions that Representative Humphreys just asked about, the main difference, and this would come from the camp that my fellow prosecutors and candidly some members of the community would be concerned about, is we are seeking to lower the mandatory minimums a little bit, or at least make it so that you could start a probation before you would have to start serving them. The problem in the current rubric is there are simply some people that 48 hours in jail or 100 hours community service is just not workable for health reasons. I'm not even talking about COVID, but just there are just some realities that having that requirement doesn't make good sense when there are other things that we can do to get them into treatment and make them accountable. Again, we're focusing here on first-time offenders. or even second-time offenders at most, where they get some relief. But what would happen is that if they couldn't get that 48 hours or those 5 days done, that probation was never starting. And it was creating a big loophole where people were not being supervised, where treatment was not being initiated, where the court couldn't hold people accountable. And we want to get rid of all that, so that just like in any other criminal case, if the court's going to grant probation, that probation should begin as they leave the courtroom, so that then the court can be informed of their performance throughout, and then hold them accountable for whatever decisions that follow. I say all that because, those lowering of the minimums, again, could be a concern, but the balance to that is something that prosecutors, and I would say judges, have been asking for a long time, which is simplifying felony DUI. And the simplest way to do it is to move it to the grid. And where we suggest putting it as a level 6, your third felony is still presumptive probation, but the benefit is that they are within a scheme that makes a more significant sentence available if they don't take advantage of that opportunity. Even a border box for your fourth felony DUI. So we're not in the business of trying to heap on a long prison sentence, but we want a significant sentence available, because right now it's not. When I tell someone that a second-time DUI and a 12th time DUI face the same punishment, that causes frustration. And that's one of the things we seek to remedy here. I'm going to reserve time for questions and also for Jay, but I wanted to just kind of stress that there's a balance here, and within each section. You may choose to scrap one section or another. That's obviously your purview, but I implore you not to tinker within the sections, because if you take off the balance of one side, the other side, it really gets out of whack quickly. Thank you very much.
Representative Carmichael with a question.
Thank you, Mr. Chairman, and Mr. Breitenbach. I apologize for overlooking the other good members of your committee who have worked long and hard. And so let me rephrase it to say that I appreciate the work of the entire Judicial Council on this legislation. My thanks to all of you. My substantive question is with respect to the bed impact statement, and I don't have it before me, but as I recall, there is a significant impact. My presumption that arises because we are putting the felonies on the grid, so to speak, and so as to make available stronger penalties for repeat offenders. Is that what accounts for the increase in bed space, or are there other factors we should be aware of, or am I just simply wrong, which is often the case?
I won't speak to whether you're often wrong or not, sir, but on this instance, you are 100% correct. It is the movement of felony DUI to the grid. Currently, these are non-grid felonies. So our sheriff's departments bear the burden of housing these people for however long a judge may impose. It is our belief that once someone is a third with a prior in the last 10 years or fourth or subsequent, that they have put themselves in a category that needs to be treated differently than other non-grid misdemeanor offenders. The quick point I like to make regarding bed space, I know there are other committees and other groups talking about reworking grids and freeing up beds and all that. It seems odd that a person who possesses felony, they have priors, so let's say a felony marijuana or a felony methamphetamine, they possess it in their hand, they could face up to 42 months in prison. They ingest it and go drive all over our roads, they might face no more than 6 months in the county jail. It just seems that perhaps as the one grid gets reworked and those beds might become available, this population that actually does endanger the community might be a better fit for the purpose of those beds.
Mr. Breitenbach, thank you for your excellent explanation, and I agree. Thank you, Mr. Chair.
Questions? Not seeing any. We will now move on to Jay Norton.
Good afternoon, and thank you for having me as well to speak to you today. I also was honored to be on the committee, and it was my pleasure to work with everybody on that group for the past 2 years, and I'm proud of the work that we did. It wasn't easy to get the bill that you have before you in front of you, and it took a lot of serious discussions, a lot of investigation to make that happen. So I'm hopeful that it will pass. I'm here today to talk about the administrative driver's license consequences that we would be proposing in House Bill 2377. As you know, when a person is arrested for a DUI, there are two separate legal proceedings that begin at the same time. One is the criminal case that Aaron has just talked about, where certain penalties apply if a person is convicted of a DUI. But at the same time, there is an administrative driver's license review that has started. And case law has made it clear that these two processes are completely distinct from one another, and they serve completely separate purposes. The administrative driver's license consequences are supposed to be purely remedial, solely for the purposes of ensuring the safety of our roads or removing dangerous drivers from the roads. They're not supposed to represent any kind of punishment or penalty, because if they are considered punitive, then you get into double jeopardy issues. So with respect to the driver's license consequences, the committee's proposals were carefully considered in terms of increasing compliance with ignition interlock requirements, and thereby increasing safety on the roads. The ignition interlock, of course, requires that a person blow into the device to demonstrate that they are alcohol-free before the car will start. And the driver has to submit to tests while the car is in motion to demonstrate that they are alcohol-free. And recent regulations of the Department of Revenue now require that each one of those devices be equipped with a camera. So this ensures that it's the person that's driving the car that is doing the blowing. And if there's any questions down the road about who may have failed a test, the camera will verify who that was. There's no question from the data in Kansas and around the country that interlock devices work and have made a great impact on reducing the instances of driving under the influence and all the bad consequences that can flow therefrom. And the current technology makes these devices very difficult to tamper with or to game somehow. They really, I think we all agreed on the committee, represent the best tool that we have to prevent people from drinking and driving. And with that in mind, the committee recommends removing the mandatory suspension period of 45 or 90 days and allowing drivers to opt into an ignition interlock restriction immediately. The reality is that the suspension periods don't really serve their intended purposes of removing dangerous drivers from the road. Many people continue to drive during the suspension period, and since they have no license, they often forego insurance as well. The Kansas Department of Revenue reports that about half of the people who are required to get an ignition interlock device don't do it. They never get it. And not only do they not get the ignition interlock device, the Department of Revenue never hears from them again, or at least not for many, many years. They are really completely lost to the wind. They simply give up on having a valid driver's license, but they don't give up on driving. And by allowing drivers to opt into the ignition interlock device in lieu of suspension, the rate of compliance with the interlock restriction will be higher. It's going to increase the number of interlock devices that are on the road, and that will directly increase highway safety, as well as increase the number of drivers maintaining a valid driver's license status, which includes having proof of insurance and otherwise complying with the requirements to show fitness to drive a car. It also means that the people who would respect a driver's license suspension don't lose their jobs. They can blow into the device and they can get to work. In many parts of the state don't have public transportation. You have to have a car to get to work, get to the grocery store, get kids to activities, things of that nature. The suspension periods put people in the position of giving up on work and participating in modern life, or giving up on their driver's license and becoming outlaws, essentially. So the thrust of the suggestions that we've made, or what's contained in the bill, really are to keep people in the fold of the Kansas Department of Revenue and get people complying with the ignition interlock requirement. And to further achieve that goal, the committee has proposed an affordability program that would make the device more feasible for more drivers. At least in the Johnson County area where I practice, and apparently in Shawnee County, it costs $150 to have the ignition interlock device installed in a car, and then $75 a month to have the device maintained. And there are other costs involved if you need to move the device from one vehicle to another, or if there's a lockout, other services that the ignition interlock providers provide. It can get very expensive, and a first-time offender who refuses a test is going to have this device on their car for 3 years. That's for a first-time person with no prior DUI occurrences on the record. It's 3 years. It costs a lot of money. And the Department of Revenue says that of all those people who are not complying with the ignition interlock requirement, about half of those fail to do so because of financial concerns, because of money. So again, we want to get people on the ignition interlock device to increase safety on the road and to separate drinking from driving, to try to change that behavior. This bill does not give a discount to everybody. It's a sliding scale. It would represent a 10% discount for some people, up to a 75% discount for the truly indigent. Most people are going to be paying 100% or 90% of the cost, but it will put more interlock devices in more cars, and the more that we encourage their use, the more that we ensure sober drivers. We keep those drivers in contact with the Kansas Department of Revenue, and we train those drivers, and frankly, everyone else in their family, that drinking and driving don't mix. In addition, the bill proposes a new requirement that before an ignition interlock device can be removed and a driver's license fully reinstated, the driver has to demonstrate that that lesson was learned. If a driver has been drinking, then the car won't start. And that failure of the breath test is recorded by the device. And when the person goes in for their monthly downloads of the data, it will be evident that tests were failed. Under the current law, a driver could fail one of those tests every single day and still get their driver's license back once the clock runs out on the restriction. Under this new proposal, they would have to demonstrate compliance. The ignition interlock provider would have to certify that they didn't have more than a certain number of violations. They didn't have any serious violations. And if they did, then they've got to remain on the ignition interlock device until they can show that stretch of 90 days without those violations. Again, these devices have cameras on them now. They have to have cameras on them. So the Department of Revenue will know who it was that failed the test and can determine whether each person has been in compliance or not. The bill also has some housekeeping issues that we're trying to clean up, particularly with respect to motorized bicycle license. That's mopeds, scooters. There's a very narrow group of people who would qualify for a motorized bicycle license. And in fact, there's only 29 of them in the state right now, 29 such licenses. But those 29 licenses are preventing the state from getting $250,000 in federal highway funds. And we think that allowing people to go straight to ignition interlock device will allow them to get to work and not have to rely on this sort of alternate means of transportation. So we're not losing much there in terms of those 29 licenses, but gaining quite a bit. As Jason pointed out, there's also a kind of a fix to a discrepancy in the law where minors under the age of 21, they're really rewarded for having a higher breath content. If a kid under 21 blows under a 0.08, they get the 330-day, almost a year restriction. Whereas had they that same kid blown over a 0.08, it would be only a 6-month. So, so the law right now encourages minors to have a higher breath alcohol content, and nobody wants that. In short, we believe that these proposals will increase highway safety. They're fair to Kansas drivers. They're going to encourage compliance with the law and ultimately benefit all Kansans by keeping more drivers within the driver's license system of the Department of Revenue, keeping them insured, keeping them educated about the responsibilities inherent in driving, and it's going to make the roads safer. And so I'm asking that you adopt House Bill 2377. And I'm happy to take any questions that you may have.
Questions, committee? Representative Jennings.
Thank you, Mr. Chairman. I'm curious, the sliding scale business, makes sense, right, in terms of who can afford what. Tell me, though, who's paying the difference? Or do we expect providers to somehow just eat that short payment? How does this work, I guess?
Well, the anticipation is that there's going to be a lot more people who actually get the ignition interlock device, and so they're going to have a lot more customers. Right now, there's a program where the providers are supposed to hold back a certain percentage of the money that they bring in order to provide interlock services for indigent people. They're not taking advantage of that. So if I'm correct, I think the understanding is that, yeah, the interlock providers are going to be giving up a little bit, but we think ultimately they're going to be gaining by having more people on the ignition interlock device.
So if I follow what you're saying, right, the idea would be that an interlock provider in Kansas would be required to serve all comers, and the determination of how much they would be paid for their service would be based upon the ability of those who come to pay. Is that in essence it?
Yes, I'm not entirely sure that they're required to serve all comers, but there would be a sliding scale, and I think the anticipation is the drivers will have to fill out an application, some kind of attestation as to their income and number of people in their household, and then based on that, see where they fall sort of in this grid or this sliding scale, and that will determine what percentage of the cost that they will be responsible for. But all drivers will be responsible for something. We think it's important that all of drivers have some skin in the game. There are a lot of states or certain states that completely waive all the fees, as I understand it, for people on the ignition interlock device. Even somebody that's at or below the poverty line is going to have to pay for at least 25% of the costs.
Representative Keither.
Thank you, Mr. Chairman. Thank you, Jay, for the presentation. I just have a comment to make that I've sat through, I don't know how many hearings about the interlock ignition device over the years, and quite often have been very, very skeptical about the use of these and how things, we year after year after year piled on tougher things in connection with the interlock system. And I am very appreciative of the work that you've done. I think this is a sterling approach to understanding different needs, even though we don't want them on the roads, but people do have needs and need jobs and get back and take care of children. And so I think the approach is really quite good. And I'm very, very happy to hear of the work that's been done with your group. Thank you for this. Thank you. Thank you, Mr. Chair.
Additional questions? Okay, our next conferee, Deborah Coffee, I think we're still trying to, she's refreshing, so let's give her just a second. We'll try to get her connected.
Mr. Chairman, I'm sorry. I can't get my hand down.
I'll take it down for you.
Thank you.
There we go. And I think Deborah Coffee is now with us. Are you there, Deborah?
I'm here. Can you hear me?
We can. Yes. You're
Okay,
up
thank
whenever
you.
you're ready.
I appreciate that. Chairman Patton, Vice Chair Ralph, and distinguished members of the Judiciary Committee. My name is Deborah Coffee, DebraCoffey, and I appeared before you last year, right before COVID hit, and I'm here representing the Coalition of Ignition Interlock Manufacturers. On behalf of the Coalition of Interlock Manufacturers, I want to thank this committee for the opportunity to provide testimony in support of House Bill 2377. The Coalition of Interlock Manufacturers is comprised of the nation's largest leading companies that manufacture ignition interlock devices that prohibit the vehicles of impaired drivers to start their car. I first want to thank the opportunity that the DUI committee did provide and that has undertaken the role to make enhancements to the DUI program and also to the Kansas Interlock program. The coalition is in favor of the recommendations by the DUI committee and had the opportunity the last 2 years to participate as an observer during their meetings. Last year, the coalition did make some recommendations to this committee, and a few of those were actually adopted and are part of House Bill 2377. We agree with the committee's recommendation on removing the route restrictions, providing DUI offenders the immediate access to driving privileges as long as they're interlocked, and including a compliance-based removal program so that offenders prove sobriety to drive before they're given back their full license privileges. All these additions, in my opinion, will make Kansas a model state for best practices for ignition interlock programs. And the coalition, we plan on going and recommending to other states that they model their programs after Kansas. On behalf of the Coalition of Interlock Manufacturers and also supported by best practices of interlock programs throughout the United States, we do make the following recommendation regarding the section on reduced ignition interlock program costs. We agree with the recommendation to improve and expand the indigent program that is currently being used in Kansas, providing for transparency and greater access for offenders. We agree that the indigent program should have an easy and quick path to eligibility, accessibility to anyone qualified, and not require workload or employees. When financial hardship is cited by DUI offenders as a reason for avoiding an interlock when the opportunity is presented, we agree of the importance to provide a cost offset for true eligible indigent offenders. To do so, there is a need to establish a criterion that is objective to determine eligibility. This bill does just that. It does establish that criteria, and we agree that people and persons in Kansas that are under some form of state or federal assistance should be able to qualify for an indigent program. The current proposal that is in this bill is a scalability program that was selected from California and grants indigent status to people earning up to 300% of the federal poverty level. We don't believe that legislation in Kansas should mirror that of California, where the cost of living is much higher. So we, the coalition, recommend that Kansas use a standard of 150% of the federal poverty level as a determinant for eligibility for the indigent program. So why 150%? We recommend 150% of the federal poverty level because that is the standard that is used in most states throughout the United States in determining indigent status. Under our proposal, individuals with an income below $19,000 and a head of household of 4 with income below $39,330 would qualify for 50% discounts on their Interlock, along with the free install and a free removal of the device. So 50% would require the offender to pay $1.38 a day or $41.50 a month, with our recommendation to waive the install price and the removal once the person completed their program. We believe that it is important that our customers have ownership of the program toward their success. 50% off the monthly lease cost of the device provides them with some accountability of the equipment and the program, while also allowing our small Kansas businesses and our contract shops to stay in business. We appreciate the opportunity, or I do, to testify. We appreciate the dedication of the DUI Advisory Committee and the Legislature to improve the Interlock program in Kansas. I stand available to answer any questions. Our desire is that you look at page 21 and strike lines 38 through 41 and amend the bill at our request on the recommendations to amend the affordability program language in the legislation. Respectfully, thank you.
Any questions, committee? I'm not seeing anyone. That is the last proponent I have listed. Is there anyone else that wants to speak as a proponent? Okay, we have written neutral testimony that's been emailed to you from the Kansas Association of Criminal Defense Lawyers. Anyone else as a neutral? Not showing anyone as an opponent. Is there anyone here or online that is an opponent? Not seeing that either. We'll close this hearing. We'll now open the hearing on House Bill 2387, and we will go back to Jason.
Thank you again, Mr. Chairman. Jason Thompson again with the Revisor's Office. House Bill 2387 revises laws relating to operating an aircraft under the influence, including prescribing some criminal and administrative penalties, providing for testing of blood, breath, urine, or other bodily substances, and preliminary screening tests of breath or oral fluid. The bill repeals KSA 3-1001 through 3-1005. Those are the current statutes governing the crime of operating an aircraft under the influence. They were enacted in 1981 and never further amended. This bill replaces them with new sections of law related to that same conduct. And I try to highlight where the old provisions kind of find their way into the new provisions and where we drew the language from in drafting the proposal in the bill brief. So I'll try to highlight those real quick. Section 1 creates the new crime of operating an aircraft under the influence and provides for the criminal penalties. This replaces KSA 3-1001. and 3-1002, which kind of separates intoxicating liquor and drugs. So we've got one section that covers both, much like we do for DUI. Section 1 closely resembles KSA 8-2 Com 144 that we talked about, driving a commercial motor vehicle under the influence, and KSA 8-1567, driving under the influence, as proposed in the bill we just reviewed. So the same penalty provisions that are in that new DUI section are found in this section. The idea was for them to match. So if you amend the DUI provision in 2377, the recommendation, I think, from the group that supports this would be to also amend the penalties over here in 2377 so that they match. I won't go into the details of it other than to say the unlawful alcohol concentration in this crime is 0.04 or more, which matches the commercial DUI provision. So that's not the 0.08 or more that's under the regular DUI provision. So I wanted to highlight that. And there's only 2 levels of conviction. So the first is 48 hours to 6 months imprisonment with all the options discussed earlier about public service and other house arrests, et cetera. And then your second or subsequent is 90 days to 1 year with the options for house arrest and work release and such. There is a provision in subsection B2 that any violation of the section is a severity level 6 non-person felony if the offense occurred while the person convicted did not hold a valid pilot license issued by the FAA. So that's where you get the felony version of this, only if you were not a valid license holder. There's also a preservation of the current law provision where where the court orders the person convicted not to operate an aircraft, and the period of time that you're not allowed to operate depends on the conviction, but that is preserved from current law. Section 2 then provides for implied consent of a person who operates or attempts to operate an aircraft in this state to submit to one or more tests of their blood, breath, urine, or other bodily substance. The tests are administered, of course, by law enforcement or at the direction of law enforcement. And they can be administered only, of course, if the law enforcement officer has probable cause to believe the person committed a violation of Section 1 while having alcohol or drugs in their system, and they meet one of the 2 criteria that they have been arrested or otherwise taken into custody for a violation of law, or 2, they have been involved in an aircraft accident or a crash resulting in property damage, personal injury, or death. So you have to have a probable cause requirement and a second either arrest, custody, or accident requirement in order to have the implied consent statute kick in. This section replaces KSA 3-1004 and 3-1005, and it closely resembles KSA 8-1001, our implied consent statute for folks operating a vehicle within the state. Section 3 then authorizes a law enforcement officer to request a person who's operating or attempting to operate an aircraft to submit to a preliminary screening test of their breath or oral fluid, or both, if the officer has reasonable suspicion to believe the person was operating or attempting to operate while under the influence. If they submit to the test, the results can be used to assist law enforcement to determine if they should make an arrest and whether they should request those tests that we just talked about under Section 2. This Section 3 closely resembles KSA 8-1012. That's our preliminary screening test statute for operating a vehicle in the state. So that's where this language comes from. And then finally, Section 4 gives definitions to be used in the 4 sections of the bill. The language for the definitions from 8-1013 are listed there. There's 4 of them. And then 2 other definitions are drawn from 8-1567. So this would attempt to define all the terms needed, drawing from those other laws. And with that, I'll answer any questions.
First question is Representative Carmichael.
Thank you, Mr. Chairman. I will not ask if we've seen this bill before because it's been 40 years since we've seen this bill before. But I note at page 6, line 42 through page 7, line 3, there is discussion of regulatory authority. And as best I can interpret this, it looks like it's supposed to be rules and regulations, if any, approved by, and I assume it's Department of Revenue. Am I reading that correctly?
Mr. Chairman, Jason Thompson again. So the provision at the bottom of page 6 on to the beginning of page 7, again, that's drawn from our current law. And I think we've had this discussion before on that topic. The preliminary screening is conducted with devices that are approved under 65.1.107, and then the oral fluid ones are approved under 712H. And yes, those approvals are both supposed to happen under rules and regulations, but there's no provision in here about when those happen or how those happen. And there's an ongoing discussion about whether that should have occurred and whether that should have been a shall or a may. You may recall some of that from the past.
And I certainly don't intend for you to address the wisdom of any of those approaches, but are these regulations Department of Revenue regulations, or is it some other agency that we're talking about?
Thank you, Mr. Chairman. Representative Carmichael, that gave me just enough time to look up 65.1.107 because I thought it was the Secretary of Health and Environment, and I can confirm it is. That's the Secretary of Health and Environment. And then the 75.712H, that would be a different, that would be the director of the KBI.
Oh, so I missed it 100% on both counts. That's why you're a better lawyer than I am on some today and every day. Well, we may want to put some deadlines in that. Thank you.
Questions for Jason? Okay, we will move on to proponents, and we have Ed Klump back with us.
Thank you, Mr. Chairman, committee. Thank you for the opportunity to speak to you today. Before I get started, I want to clarify that I'm here today speaking as a member of the Judicial Council's DUI committee, not in my normal position of the three law enforcement associations I typically represent. I also want to share with you that I gave sent Kathy a document today that has the current statutes on it that I believe has been distributed to you. I thought you ought to be able to see what the existing law is and what we're changing. So I wanted to supply that to you since it's not in the bill, since we're completely repealing those statutes and replacing them. During the discussions of the DUI laws in the committee, it was brought to our attention that the flying while intoxicated laws in Chapter 3, Article 10, were implemented in 1981 and have never been amended or updated. I did a little research, and those laws were created at the urging of the FAA back in the late 70s, early 80s. There was a lot of states that implemented state laws around that time. And the problem they were trying to address is that the federal agencies that do the enforcement of these laws or regulations obviously can't respond in a timely manner to every report of a potential intoxicated pilot or when one has been observed or stopped from flying or involved in a crash. And so I want to make it clear the federal authorities retain their authority over this issue. This doesn't take anything away from what they do in their efforts and duties. Without state laws, local and state law enforcement doesn't have the legal authority to take a person into custody and administer tests. And so that was one of the reasons for creating these statutes back in 1981 by all appearances. There's also wasn't any standard for doing any testing prior to those statutes being put in place. And the lack of the updated laws generally has resulted in the process and penalties today in the existing law being very similar to what DUI laws were back in 1981. And I think we'd all agree there's been a lot of changes in the last 40 years in both the statutory DUI laws and also in the case law. The importance of these statutes, although seldom used, was highlighted when we found at the federal level that all the public awareness campaigns suggest that citizens and airport employees should do one thing when they observe a person they suspect of being intoxicated who is either operating or attempt to operate an aircraft, and that's called local law enforcement. And so it becomes very important that we have these tools to use if we need them. We started our review of these laws by comparing the existing flying under influence laws with the current and proposed House Bill 2377 DUI laws. We conferred with the FAA. We also conferred with we have two law enforcement agencies in Kansas that are airport specific. Those are the Wichita and Topeka airports have their own law enforcement agency. And then we start a review of those laws by comparing those differences. We early on anticipated that the court would probably apply the same case laws from DUI case law into our procedures and use of the testing related to the flying under the influence. So we took that into consideration as well. Clearly, there's some things in DUI laws and case law that will not apply to flying under the influence. For example, there's no regulatory authority for the state over pilots' licenses. And of course, there's no ignition interlock devices on aircraft. And those are two examples. So as a result, we recommended a major overhaul of the outdated existing flying under the influence laws to reflect the current DUI laws and case law where applicable. And for that reason, the bill proposes repealing the entire set of laws that's in place right now and replace them with the proposed laws. So what I'd like to do, Mr. Chairman, is real quickly run through some key points in this bill and tell you what has changed from current law to proposed law. The first one, Jason mentioned the change from 0.10 in the current law to 0.04. The 0.04 is consistent not only with the commercial motor vehicle statutes, but it is also consistent with the Federal Aviation Regulation Section 91.17 and with the Title 14 CFR Section 120.19, which sets the limit at 0.04 for operators of aircraft. In the current law, there's no time period where that testing has to be conducted. One of the things we looked at in this is trying to make sure that we provided the same protections to persons accused of operating the vehicle under the influence would be applied to those trying to operate an aircraft. In this law, we are proposing a 4-hour window to obtain that test, which is different from the 3-hour of the DUI law. And the reason for that is in the Federal Aviation Regulation Section 91.17 and also in Title 14 CFR Section 120.19 subsection B, they give a 4-hour window for obtaining those tests. And we wanted to be consistent with what the federal regulations were. The next thing is the current law allows for testing by blood or breath, but it fails to address the level of alcohol in breath in the current law. And so this bill would add the phrase from the DUI laws of grams per 210 liters of breath. The next one is the operating an aircraft under the influence of alcohol and operating the aircraft under the influence of drugs in the current law is two separate and distinct statutes. And there's nothing that pulls those together to cover operating under the influence of both. And so we opted to combine those two statutes into one and to include the language from the DUI laws that covers under the influence of alcohol, drugs, or both. There's also a lack of the terminology in the current DUI laws about other competent evidence. And so we adopted that, and you'll find that language used on page 1, lines 10 through 12, page 6, line 20, page 7, line 18. We get to the penalty sections, and the first offense that in the current law is an unclassified misdemeanor with a penalty up to 1 year in jail and a fine of $100 to $500 or both. We are proposing it be an A misdemeanor. That's different from the B misdemeanor and DUI. I'll explain that in a minute. We propose the similar provisions about the 48 hours to 6 months in jail or the 100 hours of public service that's in the DUI laws. And we also propose a fine not less than $750. We felt like it was important to go ahead and make this an A misdemeanor, not a B misdemeanor, because the A misdemeanor has the potential for a fine as high as $2,500. And we thought with the additional risk involved in flying an aircraft, while under the influence, the court should be allowed to have that tolerance to impose a higher fine if the circumstances warranted. The second or subsequent offense is a 30-day minimum sentence in jail up to a 1-year max and a fine not more than $500 in the current law. We're proposing an A misdemeanor with a not less than 90 days, no more than 1 year, and a fine not less than $1,250, and must serve at least 120 hours of confinement or work release. And that's consistent with or similar to what the DUI laws are. I think the fines may be a little different. The current law never becomes a felony, and as Jason explained, we have a provision in there that if a person is flying while intoxicated, well, they do not have a valid FAA pilot's license, that it would become a felony. The main focus on that was attempting to capture those who continued to fly and did so while intoxicated after having their pilot's license revoked or suspended. Also in current law, there is a provision about the courts ordering them not to fly for 6 months and some probation and other requirements that we retained in the proposed law. In the testing procedures, we mirrored what was in 8-10,001, which Jason explained to you. The terminology in the current law is operating or has actual control, and we've proposed replacing that with operating or attempting to operate, similar to the motor vehicle laws. It also has the term deemed to have given consent, which we removed because of the case law. And then there's terminology in the current law about who can do the blood draws. Some of you may remember we changed that in DUI law. I think it was 2 or 3 years ago to update that terminology to the current titles of those people who are authorized to do that. And we proposed adopting that. Also included a Class C misdemeanor for refusal. And of course, the courts have ruled on criminalizing refusals. And so that is not in our proposed laws. And Mr. Chairman, that summarizes all of the changes, and I'll stand for questions when appropriate.
Questions? Representative Jennings.
Thanks, Mr. Chairman. I want to be sure I was clear on something, Ed. You talked about a non-pilot being penalized at a higher level of felony offense than a pilot. And you've talked about flying. Let's talk about the guy at the airport who taxis a plane, who's entitled to taxi a plane for maintenance purposes or to fuel, but they're not actually a licensed pilot. They're a licensed aircraft mechanic who is entitled to do such things. Now you're going to put him in prison, but the guy who's actually taken off and flying gets a lesser sentence. Can you help me resolve that in my mind, how that's somehow fair?
Well, either I misstated it or it got translated someplace. It's not non-pilots. It's the felony kicks in when a person doesn't have a pilot's license, a current pilot's license. And what we're trying to capture there is those who have had their pilot's licenses suspended or revoked, or something like that. The federal aviation regulations extend their restrictions over to non-pilots who perform certain functions on aircraft, including mechanics. They're under a different licensing structure than the pilot's licenses, but they are regulated by the FAA. Does that answer your question?
Close enough that I'll look at it a little bit more carefully. I didn't hear, I guess, the part that suggested they had previously had their airman certificate revoked by the FAA and that they continued to fly, which is quite different than someone who's never been issued an airman certificate but is authorized by the owner to taxi their aircraft from one place to another, which may not require an airman certificate at all.
Mr. Chairman, I had the same thoughts today and yesterday when I was preparing what I was going to say today. And I think if there was a amendment to to clarify that provision for those who had their license revoked or suspended or one of those actions listed in the federal aviation regulations. That would probably be a fair amendment to consider.
Any additional questions? Thank you, Ed. Is there anyone else here as a proponent? Not seeing any. Committee, you have written neutral testimony from the Kansas Association of Criminal Defense Lawyers. Anyone else here as a neutral conferee? Not seeing any. In your email, you also have opponent written testimony from the Kansas Agricultural Aviation Association. Is there anyone here as an opponent? Not see any. We'll close this hearing. Open our final hearing, House Bill 2369, and I think Natalie, Jason's given this one back to Natalie.
Yeah, as you can see, this one's like the most legally complicated one, so I thought maybe I should take this one. House Bill 2369 extends the closed case task force and provides for staff assistance. The bill amends KSA 216901, that's the statute that created this task force. Current law there provides that the task force expired on December 30th of 2020. So this bill would extend that to December 30th of 2021. The task force would be a continuation of the task force as it existed on December 29th of 2020. So the members that were appointed prior to that date would continue to serve as members of the task force. And then that task force is required to complete a plan for implementation of protocol relating to hits to closed cases by October 1st of 2021. The bill also provides that staff of the Office of Reviser of Statutes, the Legislative Research Department, and the Division of Legislative Administrative Services shall provide assistance to the task force as may be requested by the co-chairs. And I can take any questions.
Any questions for Natalie? Not seeing any. Is there anyone here, a conferee for, neutral, or against? Not seeing any of those. Committee, this, just a little background, this was a concept that Senator Haley, I guess he had a bill actually, I think in the 2019 session. It passed on the Senate side. It didn't either get over here in time or for whatever reason we didn't act upon it. But it did end up in a conference committee report and became law. Senator, then, well, I guess he's still Senator Wilburn. Now he's a little higher ranking, but Chairman Wilburn on the other side and I were both the co-chairs of this. We were really close, I think, to having a recommendation to come back out last fall, and just for a number of reasons, did not call another meeting and the committee did not come together. And so we missed our deadline. And so this gives us another year to achieve that deadline. And Representative Carmichael was kind enough last session in a corrections committee to give our committee some staff, but that bill didn't pass. And so this bill would also give that committee a little bit of staff just to make sure both Bob and Natalie and Jason were good at poking me to make sure we got done, but it'd be nice if they were there officially in some manner to make sure we got done in time and had a report to submit to the legislature. Representative Carmichael.
Thank you, Mr. Chairman. Just following up on what you said. Initially, when we brought this through in a conference committee report, we, because of the press of time, did not provide for staffing and resources, and hence our chairman was left with the specter of doing all the work himself. And
Didn't do it.
It's a good idea so we can get it done correctly. And I hope folks will support this bill. Thank you.
Okay, we have no conferees, so I will close this hearing. Committee, I have a list for you. I don't know that we'll have time to work bills tomorrow. If so, the ones that I'm hoping we could possibly get to would be 2093. So that picks up where we left off last Thursday with 2093, 2229, and maybe 2369, which is the one we just heard seconds ago. And then for Thursday, and again, some of this is fluid, we're trying to work some things out, would be 2078, 2154, 2227, and 2228. Again, may not get to them all. Some of them we may never get to, but those are the ones I want you to be aware of that hopefully we get to this week. And then next week, we have one more week before our deadline. Got a number of bills on the list that we have yet to hear. We'll hopefully have an agenda out tomorrow that will add some of those to the list, and then we're going to save as much time or a decent amount of time to try to work through the things that we've yet to accomplish. Because some of the bigger, more controversial things that have come before us, we have yet to work. So we're going to try to deal with that next week. That's all I have for today. Oh, Representative Ralph just reminded me we have 2 bills above the line tomorrow from our committee. So make sure if you've been listed to carry a bill to be ready for that. Let us know if you have any questions. So that's it. We'll see you all tomorrow. Stay warm. Have a good evening.